say soft 5. We'll go ahead and go on the record. Parties are present, our jurors are not present. Anything to take up before we bring our jurors in? Mr. Hunter?
No.
Mr. Hinch?
No,
All right, let's get our jurors. Please have a seat. For the record, our jurors are present, properly seated. I think where we left off, Mr. Hanner, was inquiring which or whether you wish to present evidence or testimony here today. I understand that you are under no obligation to do so. And yes, but that we did your break.
Yes, sir.
So you may call your witness.
Thank you, Your Honor. Defense would call Sheriff Robert Norris. Sheriff Norris.
Sir, you may call this a witness until please approach. Make your way all the way over here in front of Madam Clerk,
Yes, ma'am.
all the way over here. And raise your right hand and be sworn, please.
Do you solemnly swear the testimony you're about to offer in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, please have a seat, make yourself comfortable. When you're ready, Mr. Hanners, you may inquire for witness.
Thank you, Your Honor. Sheriff, since you're comfortable, would you introduce yourself to the jury and spell your last name for the record?
Yeah, I'm used to it, Mike. Is there a?
You know, your mind's all over the place.
In there, it sounds really well, so you don't have to speak in anything.
My name is Robert Norris. I'm Sheriff of Kootenai County. I was elected in 2020.
And, sorry, can you spell your last name?
My last name spelling Norris.
Thank you. Now, Sheriff, were you the elected sheriff of Kootenai County on February 22nd of 2025?
I was, yes.
And do you recall that date?
I do.
Were you involved with a town hall meeting on that day?
Yes, I was.
Now, at that town hall meeting, what was your general role?
Well, about a week before that, I was asked to do the Pledge of Allegiance. So that was my primary role, was to do the Pledge of Allegiance, and then to attend a dance competition afterwards. That was my primary role.
And did anything occur that changed that role at
Yes,
the
it-
town hall?
Yes, it did.
And what was that?
I received a phone call about 11 a.m. from a representative named Jordan Reddick.
Objection, hearsay.
Background.
Overruled at this time.
Thank you, Sheriff.
I received a phone call from Jordan Reddick, who was a representative here in Kootenai County, and he said that he had received a phone call that he was a victim of a death threat.
Objection, hearsay.
Any response?
Hearsay content.
Judge, this goes to the effect on the listener. It's elicited to show why Sheriff Norris acted differently after the fact, but has nothing to do with the truth of the matter, sir.
It will be admitted for that purpose only. Objection overruled.
Indeed.
And so I hung up with Mr. Redmond, and I called.
Sheriff, I'm sorry to interrupt you. Just to make sure it's clear, without going back through who called who, generally, what was the information?
The information was that there was a death threat against one of the representatives, and that the individual was in the area and had a specific method of wanting to kill him and his family.
So, in your mind, that changed the posture of your role at this event, is that correct?
Absolutely, yes.
And what did you start doing then?
So then I called our on-duty watch commander at the time, and our on-duty watch commander confirmed that through a Coeur d'Alene police watch commander, that the victim, in this case, did have an active death threat, and that the suspect was in the area, and that the method of how he wanted to kill this person.
The relevance of this is quite extensive.
Sustained.
Sheriff, without going into the details, we're looking at broader picture. What changes happened for the event itself?
Not following.
Based on that information, did you conduct yourself differently for the event?
Absolutely, yes.
And describe to the jury in what ways you changed what you're doing.
So when I arrived on scene, I contacted Mr. Trouette, and I told him that we had a vehicle description and a suspect description, and that if we had anybody that was available when they made their passes in the parking lot or from the visible window, if they saw the suspect's vehicle with the license plate, that they should call 911 or they should notify me immediately.
And so, at that point, you had generally requested the aid of all of the,
Objection leading.
Well, let me finish the question.
of all of the security individuals at present at the town hall.
That's correct. I asked them to.
Sustained. Hold on a second. That objection is sustained. That was leading.
What were you doing when you asked or when you spoke to the security individuals?
So, normal security protocol for any event, we want law enforcement and any security that's on scene to work together. So I contacted Mr. Trouette, and we talked about the event.
Objection hearsay.
We also talked about this event that was emerging, that of this particular vehicle with this particular suspect. So I asked him if he had anybody available.
Sheriff
and to
Norris's
disseminate it
microphone is
with
covered up.
his other security personnel, the type of vehicle and suspect description.
Now, fast forwarding, Sheriff, are you familiar with Brent Reagan?
I am, yes.
And how are you familiar with him?
Brent Reagan is the chairman of the Kootenai County Republican Central Committee.
And did you have any conversations with Brent Reagan on February 22nd?
I did, yes.
What was the nature, without going into the specific things said, what was the nature of that conversation?
As I did on that particular event and every event that I attend, I contacted Brent Reagan after I spoke with Mr. Trouette because he was busy at the time. So I contacted Mr. Reagan, and he had told me that they had
Objection hearsay.
Good. We're getting to authorities conveyed that this case suggested may not exist, or that they didn't have evidence whether or not it existed. And it's not for its truth, it's for what it conveyed to Sheriff Norris in terms of authority to act.
You have a response to that?
Yeah.
That is precisely for the truth of the matter. It's, the assertion is to have what Reagan or anyone else stated in terms of whether or not they gave authority to act on their behalf. That is exactly the truth of the matter, sir.
Well, as it's being adduced presently, it is presently hearsay. So would sustain the objection on hearsay grounds.
Sheriff, are you familiar with the KCRCC rules for town hall meetings?
Yes,
Are you also familiar, silly question I know, with your own authority as the elected sheriff?
yes,
And being at that town hall event, especially in light of the bomb threat that you had received, were you acting in your authority as the sheriff of Kootenai County?
Yes, I was.
And does that authority require you to put down any breaches of peace?
Absolutely it does. That is the number one responsibility of an elected sheriff, is to preserve the peace in the county.
Does it require you to stop any affray or try to prevent breaches of peace?
It does.
What about command or request the aid of as many citizens of the county as necessary in order to assist you in that?
Yes, sir, it does.
When you, during the event, and there's been shown video of the event, did you command anybody to leave?
Yes, I did.
And approximately how many individuals?
I know that there was a male, approximately 35 years old, that Mr. Trouette and I had a conversation. Mr. Trouette had told me, hey, objection, hearsay.
Just without stating what Mr. Trouette actually said to you, describe why the individual came to your attention.
That's very difficult to describe without including what Mr. Trouette told me about the individual. So,
Did you become aware of this individual for any other reason?
no.
Mr. Trouette point out this individual.
Yes, he did.
Did you watch the individual after that?
Yes, about 10 minutes later.
Okay. And what did you notice?
I noticed that he was yelling an obscenity and using a gesture with his middle finger, telling the forum to fuck you.
And
In a loud, boisterous manner.
And what did you do then?
I pointed towards him and I asked him to lead towards the doors, and he complied.
And was anybody in between him and the doors at that point?
Yes.
Who was that?
I don't know. I know that he was seated, or he was standing in a row, and there was several people he had to walk down to get to the exit.
So let me clarify. Did you then see Paul Trouette?
At that point in time?
Yeah.
No, he had pointed the individual out earlier.
Okay. So there was an individual that you had prior to that.
That's correct.
And which individual was that?
That was the individual that I'm talking about.
Okay. So after you asked him to leave, did you give a hand gesture to Paul?
No, I don't recall, because Paul had said, hey, if this guy continues to do this, then we might have to ask him to leave, because the situation in the auditorium was deteriorating.
Okay.
So when I walked in, about 10 minutes after that, this same individual who he had pointed out to me was saying that profanity and gesturing towards the stage.
For now, we're going to video for you to watch here in a minute. For now, you just testified that the situation inside the auditorium was deteriorating. Explain that a little.
Yeah, so I was primarily looking towards the parking lot. I had intermittently gone in and out of the room. And Mr. Trouette had told me, you know, he goes, this is starting to become a little bit different than starting to become a little bit more different than a normal town hall meeting. That the temperature in the room was starting to rise, and that there were people that were apparently real agitated inside.
Sorry for you to look chaotic.
Yes. So I had been coming in and out of the room, still looking, obviously, my main focus was this death threat, looking for an individual who might fit that description. And I noticed also that this situation was deteriorating rapidly. I I noticed that I had, and as did Mr. Trouette pointed out to me, that we had elderly people in that auditorium, we had disabled people in that auditorium, and we had children in that auditorium. And I had all of those concerns.
And so, when you came back into the auditorium, did you focus in on any particular individual?
When I came in, one of the times, the first individual that we just discussed, I focused in on him. And then I left for a period of time. And then a short time later, I did re-enter the auditorium, and I saw an engagement between a female white, who I know as Teresa Warrenpaul, and the stage. And she was acting in a very, very loud and boisterous manner. And I could feel that other people were starting to yell towards her. I felt like the temperature of the room, that it had reached a flashpoint. Had I not done something, that something would have likely have sparked off. So I had concern not only for the elderly, not only for the disabled people that were there, or the children that were there. I had concern for Teresa Warrenpaul also. I had concern that she would be the target from some of these people that were quite upset about her behavior.
And so, what did you do next?
So then, as I was walking over there, I had seen this engagement between the MC and Ms. Warrenpaul. And originally, my intent was, hey, let's come outside, let's talk about this, and let's see if we can resolve this. And at some point in time, I hear the MC say, get her out, or get them out, or something like that. Something to that nature. So I see that Warrenpaul and two other people have their arms are locked together with each other. And I asked her 6 or 7 times, come on, come with me. I identified myself as the sheriff of this county. I said, come with me, let's go outside. And she refused each time.
And what did you do next?
And then I attempted to use a come-along technique to ask her to come with me outside. And she again refused. And at this point in time, there was 2 security officers that were there. And I said, she needs to leave. And I took their phone, and I recorded the event. And then there was a gentleman who I want to say about 60 years old or so.
Are you referring, let me stop it, to the individual that you asked to move prior to addressing Ms. Warrenpaul?
That's correct.
That individual has been identified as Gregory Johnson.
So I asked him to get up from the seat, and he complied. And then as I was dealing with Warrenpaul, and mind you, I still have all of this commotion going around all of the whole auditorium with people that are focusing a lot of anger towards Ms. Warrenpaul, still having the mindset of all the vulnerable population that was inside, and I had that death threat. So then Johnson originally complied, and then he started to encourage. Now I had to encourage Warrenpaul to keep resisting my efforts to have her removed. So he was already standing up, so I escorted him to outside in the hallway, and then I left him out there in the hallway with Mr. Trouette.
Now, that specific event, you started escorting Mr. Johnson out of the hallway. At what point in time did Paul join you?
I think probably within the first 10 or 15 feet, if I recall correctly, but pretty quickly.
And why do you think that is?
Well, just to assist me in trying to preserve the peace inside this auditorium and prevent anybody from getting hurt.
And without going into anything specifically said, had you guys had discussions previously as to preserving the peace?
We had overall discussions of the event, and I told him that I would likely stay there. I was going to be there because of this threat, and the fact that there was no Coeur d'Alene police officers that were present during this death threat.
So, we've seen video of the removal of Mr. Johnson, and it shows you and Mr. Trouette taken out into the hallway. And then you leave, and just testified, you leave Mr. Johnson with Paul, is that correct?
Correct.
And then on the video, it appeared that you turned back and you guys had some kind of conversation. Do you recall the nature of that conversation?
I do. I don't know exactly what I said, but I do recall. I remember telling him that Coeur d'Alene Police is on the way. You stay out here and handle this situation. I'm going to go in and make sure everybody's okay inside. Something to that nature. I don't know exactly what I said, but I know that I was that somebody, as I was walking, hey, do you want me to call the Coeur d'Alene Police? I go, yes. Call 911. Tell them the sheriff's here. Tell them we need to be in that situation. In that chaos, I don't know who that person was. And then that's what happened outside of them.
Okay. And then when you went back inside the auditorium, what did you notice?
I saw that that Ms. Warren Hall was out of her seat, and she was on the ground, and she was using her legs to hold on to parts of the other chairs and what have you. She was appeared to be resisting, and the security officers were attempting to remove her from the auditorium.
And just to be clear, the removal of all of these individuals, what was your purpose of that?
I needed to preserve the peace inside that auditorium. I wanted to make sure nobody was going to get hurt. I feel like the fever, the temperature in that particular auditorium had reached such an event that something like that could have sparked off a melee. And yes.
It's State's Exhibit 22.
Sure.
Judge, permission to use the launch as a witness in regards to
Mr. Anderson, what are you doing here?
Judge, I want to show Sheriff Norris and have him explain it's the removal of the Russell dog.
Which exhibit are we?
This is, sorry, State's Exhibit 20.
Any objection to publishing State's Exhibit 20?
No, just to clarify, I think,
Stallings, yes,
just wanted to clarify that, I think there's mention Russ Dunn, I think it's the removal of that install.
With that no objection, Exhibit 20 shall be published.
Sheriff, previously testified that Stallings was sitting over in that area. Is that what we correct? Is that what you're
That's correct, yes.
And is that, I'll really quick, just so that it's clear, is that the individual that you referred to earlier that was shouting profanities?
Correct.
Okay. before you try and get to the pertinent portion.
Any objection to fast forwarding this exhibit, Mr. Hunter?
No, Your Honor. I certainly have my
And Sheriff Norris, you can come over here and take a closer look if you need to, but the individual that just blocked up the hat, is that you?
It appears, yes.
Back up just a little bit. Sure. Direct your attention again if you need to come over and take a closer look. Because like that is you addressing Mr. Stallings, is that correct?
Correct.
And that's the moment that you testified, you heard him screaming the obscenities and you asked him to get out of there.
Yes.
Okay. Now, you play, he said he listens to you, he complies. And there he is walking down the ramp. Now, you seem to be making hand gestures there as Mr. Stallings walks out of the auditorium. Who are those hand gestures towards?
I don't recall.
Oh. Okay, that's all I need that for. No further questions.
Everyone, thank you for being here.
Thank you, Brad.
Probably not under the most cordial of circumstances or inviting, but just want to ask you some questions, go through some of the things that you testified to. Hopefully we can have a conversation about what you call. There's a comment about one of your statutory duties as the sheriff of Kootenai County is preservation of the peace. Does preservation of the peace to you mean that anytime things get a little rowdy, get a little local, that you're obligated to intervene and stop that?
Each situation is different.
Okay. Well, let's confine it to circumstances similar to this. Public high school. Would you agree with that?
Yes.
Public officials were present.
Yes.
And although it was sponsored by ACRCC, which is a private entity, it was open to the public. Would you agree with that?
Yes.
The tickets required, no restrictions on who could attend. If someone wanted to attend, they could come, they could attend. Would that be accurate?
That's correct.
So on this set, let me back up a little bit. You attended California Post, for that correct?
Yes.
And then came up to Idaho, was that 2017 timeframe?
Something like that.
Challenge.
Purchased my home in 2013.
Oh,
Yeah, so,
do you challenge Idaho Post?
no.
Oh, okay. Do you currently hold any certifications through Idaho Post?
No.
But you did attend Post in California, and I'm assuming that included quite a bit of training on probably a wide variety of topics.
Absolutely.
Did that include training with regard to how to respond to, call them, maybe this isn't the apt term for this particular situation, but it kind of gets us to where I think we need to go, which is protests. You see training on dealing with protests in public spaces?
Absolutely.
And you'd agree that that training included the preference, maybe? I don't know if I'd call it an explicit requirement, but admonishment to give a wide berth for First Amendment rights, people to be able to have voices heard, and certainly to a limit. Would you agree?
Objection, Justice O'Connor.
I'd like to answer that question.
Absolutely.
So, in this country, the public sidewalk and public parks have a high expectation of First Amendment right. High expectation. This event, under Herndon versus Sandpoint.
Objection, Your Honor. The defendant is actually making a legal statement that is not responsive to my motion.
It is responding to your question.
Not the side of case law.
Mr. Hunter, it is responding to your question, your open-ended question. The witness can respond. Go ahead, sir.
And under Herndon versus Sandpoint, a public facility was rented to a third party, and that third party set the rules for the space within that public building. That was a 2019 case. So this is very, very similar, that it's a third party entity that set rules and said what those rules were beforehand, and gave an opportunity for the participants to engage with the legislators at a particular time, just not at that particular time when others were making a disturbance inside.
You're not a lawyer, correct?
No, I'm not a lawyer.
Not
I
passed
make
yet.
it honestly, I'm not a lawyer, no.
So this is just your off the cuff reading of a case that you think is applicable to this case, correct?
Well, according to the AG.
It's a yes or no question.
According to the AG.
No, it's a yes or no question.
According to the AG.
Sure.
According to the AG.
Asking
Hold on.
correct witness.
Hold on.
So only answer the question I asked. I asked a yes or no question.
Can you re-answer your question?
What you just testified to is based on your interpretation of that case you referenced, correct?
Correct.
Do you understand what the concept of distinguishing facts in a legal context is? Understand that you're not a lawyer. Are you familiar with that concept?
Your interpretation and my interpretation might be different, but continue.
And as you indicated, I am a lawyer. I do not make them, honestly.
It was.
So in reading facts of that case, that was actually a rental of a fairgrounds. And there was a lease agreement, a formal lease agreement. Would you agree that that's, you noted that fact in that case?
Correct.
And that lease agreement was explicit in its grant of property rights to the lessee, correct? That was the finding of the Supreme Court.
The Supreme Court decided for the city of Sandpoint, yes.
And that was because there was a lease agreement. Now, you're not aware. And so there's a distinction between the rights that an entity gets, objection, counsel testified. In your reading of that case, did you notice that the Supreme Court relied heavily on the language specifically contained in that specific lease agreement, reaching its decision as to what took place in that?
I did not read that particular portion of what you're referring to.
Okay. So, safe to say that being not a lawyer, it's not entirely certain, you're not entirely clear that that case has any relevance to this particular situation. Do you agree?
I would disagree.
Let me ask you some questions with regards to, going back to the question I actually asked you, which was about certain peace. So, again, that would not include someone simply making one statement in a public high school during a public event with public legislators. Would it?
With one statement, I would probably say no. And it's a hypothetical, but I would probably say no.
So in terms of being able to preserve the peace, there's still, as far as any individual actions that you take in your capacity as sheriff or any individual, you'd still be required to follow the law as to whatever action you take. Would you agree with that? I can simplify it if it was a little verbose, and I apologize for that. You as a sheriff still have to follow the law, don't you?
Absolutely, yes.
And that includes individual rights. Do you agree?
It does, yes.
It includes compliance with Idaho statutes and say, like, in context, if you're going to arrest someone, for example, you have to comply with the Idaho statutes that pertain to arrest. Would you agree?
Absolutely, yes.
Are you familiar with which statutes under Idaho code pertain to arrest?
As it pertains to trespassing or?
Just as to the requirements for a peace officer or a citizen engaging in the act of arresting another individual.
Arresting somebody.
Well, that's not what I asked. I'm just asking if you're familiar.
Yes.
Off the cuff, do you know which statute it is? Probably not a fair question. It's 19-602. And then several others. 19-601. That defines what an arrest is. 19-602 defines how an arrest is made. Are you familiar with that particular statute?
Yes.
And in your training experience, would you agree that that statute requires that, quote, an individual must not be subjected to any more restraint than is necessary for arrest or detention?
Correct.
And when a private person may arrest, are you familiar with that, citizen's arrest?
Yes.
In order for somebody to arrest for public offense, that has to be committed in their presence. That applies to peace officers as well, wouldn't it?
Yes, it does.
Is it a violation of law to say in obscenity?
No.
Is it a violation of law to even make a obscene hand gesture?
No.
So your testimony here today is that you recall one individual, I think it was installing, your recollection is that you claimed he said, quote, "fuck you," and made an obscene hand gesture. That's your testimony.
Correct.
Your testimony is that you, after you told Mr. Stallings to leave, simply hearing him say that. Is that correct?
He was not promoting a harmonious exchange of thought in the auditorium, and he was not speaking what he was supposed to be speaking towards the end of the event.
Neither of those are criminal offenses, are they?
No, but they do fall under my authority to preserve the peace.
So going back to my initial question, it's your belief that preserving the peace means that you can decide that someone has to leave an event held on public property with public legislative officials, any amount of disruption.
I didn't say that. I didn't say that. I said to take the totality of all the circumstances that were present, not just one particular, you're trying to hone in on one particular area. I'm taking the totality of the whole situation.
So let's say in,
And had I not done nothing and they broke into a melee, they would be asking, "Sheriff, you were there, why didn't you do it?"
let's talk about that precisely, and for taking us to that point, because I have some questions with what you were there for. Your testimony was that you were there in response to a bomb threat against one of the legislators. Is that correct?
Yeah, correct.
And that
That's
death threat
the
was,
way they're arrested, yes.
and that was
That day.
specifically a bomb threat, was not?
5 gallons of gas in his vehicle, looking for a representative, and he hopes his kids are in the car at the time. Yes, it's a death threat using bombs. So,
The bomb threat.
Sure.
And in training and experience, you would agree, would you not, that when dealing with a bomb threat, it's not standard procedure to do that alone?
Each situation is different.
But as a general matter, as a best practice, is there ever a time where the best practice is to engage with a potentially lethal suspect on your own? Unless you absolutely have to. Right. And so, in this context where you became aware of a bomb threat involving a public legislature, you surely called Coeur d'Alene Police Department to inform them that that was going to potentially be taking place within their jurisdiction.
I was shocked that they weren't there.
That's not responsive to my question.
I was shocked that they weren't there because they were the handling agency of that death threat. And Representative Redmond told the Coeur d'Alene Police that he was attending this event.
Let's talk about that. There were, in fact, Coeur d'Alene police in the parking lot at this event, were there not?
I saw them one time during, while I was watching the parking lot for this white.
And so, when we ever get Haley on the stand, or even Officer Taylor, who was responsive to this event, get her on the stand, have her testify that she was in fact in the parking lot that morning, for the duration of the event. Did that surprise you?
It wouldn't surprise me. All I'm saying is I saw them one time. But being in the parking lot and being where the victim is with his children, there's two different locations.
That's understandable. My question to you, though, was, and I don't know if you directly answered it quite yet, is did you coordinate with the Coeur d'Alene Police Department in your decision to help this active security in response to this death threat, this bomb threat?
It was a Coeur d'Alene police investigation. I was shocked that they weren't present when I got there.
So Sheriff, is that a no?
We have limited resources out there. I knew that the suspect was in the area. And so I knew they were working that suspect in the area. It's not like we have abundant deputies and police officers out there. We all have to pool our resources. So did I know that they were working the suspect in the Coeur d'Alene area? Yes, I did. Did I believe that based on the information and who we had on scene looking out for the individual, was that sufficient? Yes, I did, based on the resource that I had available to me at the time.
I guess just to clarify, so is that a no that you did not engage with them before?
No, I said no. I was shocked that they weren't present when I got there.
And despite that shock, you didn't take any actions to reach out and say, hey, I didn't see you guys in the parking lot. Are you coming to address this bomb threat? There's about 450 people that might be at this event.
I feel like that should have been done without me having to tell them to do it.
Oh, so that was somebody else's responsibility.
I feel like it should have been
It is
done.
argumentative, sustained.
Oh. So relying on the Coeur d'Alene Police Department to deal with a bomb threat within their jurisdiction, would you agree with that?
Correct.
But you decided you would play some role, I guess.
I don't object as to relevance, I don't know why we're still dealing with the long
Sustained.
Now, Sheriff, when you get inside the auditorium, that still remains your main focus was to address that. Your focus was not crowd control, so to speak.
Yeah, my focus was Pledge of Allegiance and monitoring that area of Bright City parking lot, which happened to be the portal into the auditorium also.
So you're monitoring the parking lot, but also within the auditorium?
Yeah, that east hallway, the east hallway was the main entrance to the auditorium. So I could see the parking lot and I could see the individual. In the event the individual would park in the residential area and walk over or park behind the school. So from that vantage point, I could see the parking lot and the main entrance.
You mentioned, we spoke a little bit with the defendant prior to this event, is that correct?
Correct. Prior to the meeting, or to the start time of the town hall, yes.
And then, just to clarify, if the meeting, did you understand what the defendant's purpose was there to be in terms of supporting the security for the event?
Yes.
So as far as you understood it, defendant was going to be able to potentially cover that side of things as well.
Inside the auditorium, yes.
And you still kept checking in, even though there was a sponsor too, that you testified you were trying to stay connected to the party.
Right, and through, as minutes passed, I could tell that the decibel level inside of the auditorium was getting louder and louder.
Is there a point at which the decibel level becomes illegal?
No, but it became more alarming to me.
Despite that not being the focus of why you were there, and
Correct.
purportedly security there to handle that side of things.
That's correct.
Your testimony is with regard to the disruption that ended up occurring and your observations with regard to Gregory Johnson. Your testimony is that he encouraged Teresa to resist. Is that correct?
Yeah, I think he said something to me or to leave her alone.
And so in your view, that encourages someone to resist? Resist what?
And like I said, when you have to take the totality of all of the situation, the level of the temperature, the loud behavior, and the fact that I was the only peace officer there, and the fact that now I'm Now I've got this that I'm dealing with over here, and then I believe he was over here to my left. So yeah, I was then, my attention was brought to both sides of it, so yes.
As to that point, as this meeting, I think you mentioned that his temperature started to rise, you said you made a comment when his descendant or began deteriorating. Did you call for the aid of deputies when it started to seem like the meeting was getting a little out of hand?
Because most of the people that I had asked to leave complied when we asked them to leave. And generally that's the case 99% of the time. When we ask somebody to leave, generally they leave.
And that person that you asked to leave was Benjamin Stallings, after he allegedly said we had seen statement?
Yes. And there were,
So just that one person?
no, there were 2 other people that had firearms that we asked to leave, and they left also.
In fact, wasn't that after the fact?
They asked me, hey, we have 2 people with firearms, Sheriff, what would you like to do with them?
And that was after all this disruption took place, wasn't it?
Yeah, but part of it was during.
So that wouldn't be
the
relevant
actual-
to your assessment at the beginning, would it?
That's, what's that?
It wouldn't be relevant to this totality of the circumstances that you're talking about at the beginning when you first removed Ben Stallings.
No, it goes to the generality of when we ask people to leave, they generally leave, yes.
So Sheriff, let me ask you this question. In your training about probable cause, you don't get to use, say probable cause for an arrest. You don't get to use something that occurs after the arrest, 20 minutes later, in your determination of a basis for arrest, right?
No, I think your question was more general.
It was not, actually. These 2 individuals that were with no recollection of how this event took place. Those 2 individuals with firearms were told to put their firearms back in their vehicles and leave after all of this took place. Correct?
If I recall correctly, I was told during that we had 1 person with a firearm. And then afterwards, I was told that we had another person with a firearm.
Kootenai County Sheriff's Office have a bomb squad?
Have a, sorry, what?
A bomb squad?
No,
For the police department?
no.
They have a special response team?
Objection relevance.
But you did not call any deputies during the course of any of the events that took place
Objection.
on this date, is that correct?
Overruled, yes.
That's correct.
You did not place any call to 911 or to dispatch for lane police officers, correct?
Somebody asked me, do you want me to call? I go, yes, I do.
Would that be a no?
Did I call? No.
Sheriff, after this event occurred, let me back up. In your training and experience, you get involved directly in the, any kind of enforcement action or use of force. Standard procedure is to generate a report, is it not?
Generally, yes.
You'd agree that would apply top down, and applies to any member of the sheriff's office, or the police department, any law enforcement agency. They're involved in a case that ends up criminal charges that should have a report written. Don't you agree?
Beyond the scope and relevance.
Generally, yes.
And is it true that you did not write a report despite your involvement with this case?
I did not write a report for submission, correct?
Does your department have use of force policies?
Yes.
Do those use of force policies require that when force is used that you generate some form of a report or just identification that force was used in a particular context?
Yes.
But you did not generate a use of force report or anything similar based on this incident, did you?
Correct.
representation was made by the sheriff's office that an internal investigation is going to be conducted into your actions as a result of this event.
Correct.
But that internal investigation was never done, was it?
Objection, relevance.
Mr. Ledger,
This
relevant?
goes directly to credibility. Also presenting the court's know the extent of authority. The question becomes whether he complies with his own policies.
And parties would like to approach? Mr. Norris?
Withdraw that question. Sheriff. Just a clarifying question for you before I ask you a few final ones to wrap up. As far as what laws you as sheriff are able to enforce, do you agree that you don't have any ability or jurisdiction to enforce the municipal codes of the city of Coeur d'Alene? Correct.
Correct.
You mentioned that you were familiar, or you may have mentioned that you were familiar with Trouette Trial prior to this date.
Yes.
Prior to this date, you didn't know any of the other individuals that you had physical contact with or engaged with?
Yes.
In that prior engagement, be safe to say it wasn't entirely positive, was it?
I wouldn't say it was negative. I mean, I think,
I mean, it's not public statements you've made, public interactions. You're not entirely a fan of Trouette Trial, fair to say?
I would say I'm neutral. I'm the sheriff for everybody here in this county. I would say I'm very neutral. I know that they have a particular political view, but I wouldn't say that I hold any disdain for that.
But at one point, I just want to ask you a couple of questions about the NC's economics role. Your testimony was that at some point, Ed had specifically asked Teresa, yeah. Is that your testimony?
No, the testimony was that as I was conversing with her, I heard the MC say, "Get her out," or "Get them out," something to that nature. So get them out.
I want to show you something with regards to that in just a moment. But first I want to ask you about some other comments, thoughts on a couple of the other comments that the MC made to you. Your testimony was that the meeting began to deteriorate. You agree that Mr. Peterana did not help with that condition, correct?
I would agree that he could have acted better in this.
And you agree, wouldn't you, that by singling out Teresa Bourne-Bold, at one point, prior to your interaction with her, he didn't ask her to leave at that point, did he?
No.
And in fact, he used a diminutive term, if you will, to refer to her, didn't he?
I believe, there was some back and forth. I believe that it could have been better. I don't know what term was used.
And so just
Maybe it was just kind of getting the little girl or something. I don't know, something like that.
you agree that's not really a respectful term to use for an adult
I
woman.
think it could have been better.
And you'd agree that that in no way helped de-escalate the circumstances in that auditorium?
Cool. Yeah, but I'd like to elaborate on that.
Well, there will be redirect, you'll have an opportunity there. And you agree that at no point you went up to Ed and said, hey, dial it back, take it down a notch, let's lower the temperature, let's do that.
That's false. I actually told them to stop.
Okay, you told them to stop.
I told them to stop, and I told everybody to go behind the curtain. So
And that was,
Hold on, there's a bit of interruption here. Please allow the witness to finish the answer before you ask the next question. Go ahead.
So at one point in time, I asked the moderator, the MC, master of ceremony, and all the legislators to stop talking, stop engaging, and go behind the curtain, because I wanted to preserve the peace in this auditorium.
and that was after, or either that or immediately before you were approaching to raise the point. Prior to that, when Ed Bakeron made the comment, everybody looked at the little girl. You didn't go and tell him, hey, that's not good.
No, I did not, no.
When he, previous to that, and I don't believe this forum was present for this, but previous to that, when he made the comment, shut the hell up or get the hell out, you didn't tell him, hey, maybe that's not the best way to dial down the
I recall seeing something, or hearing something like that, or seeing something like that in the video afterwards, but at the time, I don't know if I was inside or outside. I could have been inside, but I believe that his actions could have been better, yes.
Your testimony here today, Sheriff, is that you spoke with the defendant beforehand.
Correct. Before the event?
Before the event.
Yes.
Finally, approach the witness room.
Do you have it?
What's that?
What do you have?
I had, what's been marked for identification purposes, State's Exhibit 15.
You may.
Sheriff Norris, I'm handing you what's been marked for identification purposes as State's Exhibit 15. In the aftermath of this event, you recall making statements to the press regarding your involvement in this case.
Objection, hearsay.
Response, Mr. Hunter.
Judge, it's not hearsay, it's in a published article, it's a publication of the agency, some authenticating.
We're not talking about authentication. What hearsay exception exists here for the mission of this exhibit, proposed exhibit?
Regarding self-authenticating, I think that in and of itself foregoes any hearsay issues, otherwise not being self-authenticating because of hearsay if there is one. But it would also, statements, published news articles. And it's not being admitted at this point. This is also for impeachment purposes, so. The defendant's own statement, or the witness's own statements, and contradicting the statements he's now made on the stand.
Mr. Hunter?
Objection. That may be true if the document was authentic, but frankly, anybody can type up a document saying that the sheriff made certain statements, and then accuse him of lying on the stand based on the statements in that document. We still don't know what that document is, there's information, and there's hearsay, there's no way to authentic, or to ensure that it was actually a statement made by the sheriff.
That's document at this time, asking the witness about statements he previously made.
All right, I'm going to overrule the objection, subject to further objection. Exterior reflector remain.
And the question before the sheriff is, you recall making statements to the press in the aftermath of this event regarding your role. Do you recall making statements to the press in the aftermath of this incident?
I recall having conversations. I was at a dance competition. It was loud. I don't dance. I don't competitively dance, but my daughter does. So I remember having some conversations. I would have to review this to see. I don't even know what you're referring to.
That's what the question before you was just, do you recall making any statements to the press in the wake of this event?
I don't recall exactly what I told the press now.
But you would agree that you did make comments to the press? Would it surprise you to learn then that, so from Sheriff's argument,
Counsel says that this is impeachment. The witness has just testified that he doesn't recall the statements that he made to the press. Counsel then reading him the statement and asking if it surprised him is not appropriate. There's still nothing on the record that any of these statements are accurate. And the witness testified that he doesn't recall what he said to the press.
Ladies and gentlemen, it's just about noon, so I'm going to excuse you for purposes of lunch, so that we may work out some issues. Please remember to not discuss this case amongst yourselves or do not form a decision on the merits of the matter until it is fully finished with your information. Have a nice lunch.
all rise.
Not yet. Go ahead and have a seat, please.
The questions, and I'll question.
And I'm sorry.
I said, and I'll withdraw the question. I'm not going to seek to amend the article. I'll conclude the question.
So you're done questioning Sheriff Norris? So when we come back from lunch then, we'll have, three correct.
Yeah, Judge.
Okay. I should make the record that jurors are not present for present. Anything we need to address, so we'll take our lunch break as well. We'll have the parties come back at 1. But that said, the parties, my preference would be not to have any robust evidentiary discussions again this afternoon. If we can have them over lunch or a portion of lunch, so we're not making the jurors wait again. And so for that purpose, is there anything else we need to address here before we take our lunch break, Mr. Hunter?
Nothing.
Mr. Henners?
Your Honor, I have been informed that a certified copy of the AG's letter is forthcoming, and there was an expectation that I might have that over the lunch hour. So certainly, if that comes to fruition, see, I'm not been involved in those conversations, so I don't have all of the details. But if that came, was able to, I would seek to discuss that with the sheriff as well as introduce it to them.
Mr. Hunter, do you have anything for you?
Absolutely.
But you will have to come back at 1 o'clock. Not quite done yet. Okay, thank you. Understanding the court's previous ruling as it relates to the admissibility of of Defense Exhibit A, that it does qualify for admission under 8038. As a record of a public office, which resulted in factual findings from an investigation conducted under legal authority, included factual findings from special investigation, either a complaint, case, or incident. Understanding the court has indicated that Exhibit A appears to qualify under that exception, so I don't think we have any more argument on that. We did discuss the concerns related to foundation, or how the exhibit may be admitted into evidence. I'm understanding from Mr. Hanners that he's going to seek to admit this exhibit through Sheriff Norris. Your response, Mr. Hunter?
Well, I'm going to reserve additional argument. I'll be renewing based depending on what the actual document that there's potentially be self-authenticating, whether it is in fact ends up being able to be self-authenticated. And I will be renewing my objection to the notice element. Again, it is exceptionally late in the day, on the final day that has been set aside for trial. Had I known that this was going to be proposed to be introduced, had I been made aware and properly disclosed a copy of the document in discovery, that would have fundamentally changed the trial preparations. It would have fundamentally changed the state would have advocated for the terms of trial preparation. I have no time left to put on a sufficient rebuttal case, and in that in and of itself is unfair prejudice. It is not a question of notice of the document's existence, it is a question of notice of its intent to be introduced, and that was not known until late in the day yesterday. And for notice, I still get even been, I was never even provided with a copy of the document that counsel sought to introduce, which shows what is state's exhibit or defense exhibit A is in fact a copy of the letter. I presume that to be the case. But I've never actually shown it. There isn't a copy. And so I will be asking the court to reconsider that aspect of prejudice in this case. We are going to be confusing the juries. I'm going to ask the court to reconsider that aspect. They will be given legal opinions that are not relevant to the defendant, to what he did. There's been testimony by Sheriff Norris that was very clear that he never gave a command to the defendant himself. And so whatever relevance there is for purposes of the sheriff's, the authority, the lawfulness of his conduct has been now made moot, because the evidence will not show, the evidence does not show, that this defendant has ever commanded aid the sheriff in performance of one of his authorized duties. And so based upon that, based upon the risk of confusing the issues, misleading the jury, the risk of undue delay, we're already less than half a day now left for purposes of this trial, in consideration of not wasting the jury's time with something that is collateral, that is not relevant to their ultimate decisions to be made in this case, renewing still until further provision of something to the contrary, the foundation and authentication issues. The state would again object on all of those bases.
Mr. Henry, your response? All right, Madam Clerk needs a break. I need a break. I imagine you guys need a break. so let's go ahead and take lunch, I'll come back with my decision, come back at